Good afternoon, everybody, then. Welcome to today's NEC webinar, which is NEC Case Law. My name is Jennifer Patel. I am Business Support Officer for CECA based in Yorkshire and the Humber. We're grateful to Sarah Wilson of Bevan, Brittan, who'll be delivering today's session. Now, in terms of housekeeping, you should all be able to access the chat function. So if somebody could just write in there to let us know that you can see and hear us, that would be great. Perfect, thank you very much. So we know that you can see and hear us. That's a good start. Now, as always, a copy of the slides will be emailed to you after today's session. And because today's session will be getting recorded, the recording will be uploaded to our YouTube channel after the webinar's finished. So I'll attach a link to the YouTube channel as well in the email that I send out to you with the slides on. So if you want to share that with your colleagues, then please feel free. Now, if you require a certificate for CPD, then just drop me an email after today's session and I can send a certificate over to yourselves. And lastly, if you've got any questions for Sarah, then she'll be more than happy to answer these at the end of the session. So if you want to add them into the chat as we go, and then we can ask those to Sarah at the end. So without further ado, I'm delighted to hand over to Sarah for today's session. Thank you.
Hello everyone, thanks Jen. Yep, so today we're looking at NEC case law. So if we have the next slide, please, Jen. I think we can maybe, yep, so we can skip over that bit. Right, so the NEC form of contract, still a fairly young contract, even though it's 30 years old now. The case law is gradually increasing, but there's not a huge amount of it. And as it says here, much of it's from Scotland and Northern Ireland. It's persuasive, but it's not binding on the courts in England and Wales. So what that means is that basically, you know, if it's a case that helps you in a particular scenario, you will be saying, you know, that the English courts are likely to follow it. If it isn't, then you'll be saying the opposite, and you'll find that, you know, the other party will be arguing in support of its case. So next slide, please, Jan. So we've got 20 cases today, so that's quite a lot. It says the oldest is from 2010. That's not actually correct. There's one that's 2008. But you'll see in terms of case law, that's all fairly recent. And I think what happened was, you know, for the first 10 years of NEC, nobody used it very much because it was a new contract. You know, nobody understood it really. Then for the second 10 years, we started to use it, but we were all, including the lawyers, I think, quite reluctant to take it to court, partly because it is this innovative contract that talks about things in present tense. You know, it's fairly succinct. So that means from a lawyer's perspective that, you know, it sometimes tells you what you do in a certain situation, but it doesn't tell you what you then do if if another party hasn't done something that they should do. So there are arguably a few gaps in it. So what I want to do today is not kind of look in detail at any of these cases, but to kind of highlight the themes and hopefully highlight how they are relevant to your job, whether it's negotiating the contract at the start, sorting out the final account in inverted commas, because of course in most NEC contracts there is no such thing, and also sort of arguing your position, negotiating and trying to get a resolution on disputes without taking matters to adjudication. So the 20 cases pretty much cover all of the NEC case law. So why I've done that is so that you go away knowing where there is case law that covers a point in the NEC, and then conversely, you know that if there's a clause that's not particularly clear, If it's not covered today, there's no case law to help you determine what it might mean. Also, I'm going to try and sort of explain how you might be able to use it and how one principle might be relevant to something else in the contract. So we've got a whole load of interesting topics. Mutual trust and cooperation is dealt with, pricing and compensation events, which I'm sure you'll all be interested in. And also there's quite a lot on the dispute resolution processes. Next slide, please, Jen. So the first case, so how I've kind of formatted this is there's probably going to be a slide to 2 slides per case. We've got the MT and C, so that's my abbreviation for mutual trust and cooperation. So that's the issue that it relates to. We've then got the name of the case, so they're the 2 parties, and then we've got this funny bit at the end, which is the case citation. So this is the sort of unique court reference. So it shows to us that it's a 2017 case, so fairly recent, and the last bit shows it's TCC, which is the Technology and Construction Court, which is where most of the construction cases are dealt with. It's an arm, it's a section of the High Court, and what it means is that typically you can rely upon the judge who hears the matter having previously been a construction barrister. So that they're people who know about construction law, they understand construction projects, etc. So mutual trust and cooperation, this is the sort of flagship USP of the NEC form of contract. It's the first clause in the contract, so it's clause 10.1. All the parties to act in the spirit of mutual trust and cooperation. It was dealt with in this case, and it's the 3rd and 4th bullet points that summarise it. So it means that the parties must be honest, fair and reasonable and don't attempt to improperly exploit the other party. And also the case found that the parties can't keep quiet if it might mislead the other party. There's a positive obligation to correct a false assumption being made by the other, but there's not an obligation on one party to educate the other in how the contract works or what the contract requires that other party to do. So if we can have the next slide, please. So as is sometimes the case with case law, the kind of background is a little bit convoluted. So we actually, the issue was whether the subcontractor had started adjudication proceedings within the correct timescales under the contract. So you might be thinking, well, the Housing Grants Act says you can adjudicate at any time, there aren't any timescales, which is right. But remember, to come within the Housing Grants Act, you must be operating as a construction operation. And this, you'll see from the 2nd bullet point, related to a supply contract, which doesn't come within the Housing Grants Act because it's just supplying materials to site. So it's not within the Act because the Act requires some form of construction operation. So in this, as you can see from the 2nd bullet point, we had 2 conflicting clauses in the contract. So there was an NEC framework contract, which allowed adjudication at any time. Then the supply contract contained a time bar for bringing an adjudication. So this is similar to the W1 provisions in the engineering and construction contract, where you don't come within the Housing Grants Act. So the issue was whether Costain had to comply with that time bar or whether it could adjudicate under the framework contract and not have a time bar. And the adjudicator and the court found that the time bar did apply. It was a supply contract, and it was those provisions that applied to the contract, and therefore Costain was time barred from bringing the adjudication because it hadn't complied with those timescales. So that's one point. So then Costain argued that the fact that it was time barred was part of a breach of mutual trust and cooperation, and it was sort of along the lines that Tarmac should have warned Costain, misled Costain into thinking that the supply contract time barring didn't apply and they could adjudicate at any time under the framework contract. Now, just to be clear, the court found that there was nobody misled anybody in this scenario. But the court went on to look at circumstances where mutual trust and cooperation might be relevant. And what they said was that Tarmac, and this applies to all parties, and as I say, there wasn't any finding that anyone had been misled, but the court said that Tarmac couldn't deceive Costain that the time bar was inoperative. They would have to correct a false assumption that Costain was made, but Tarmac didn't need to go any further under the mutual trust and cooperation clause. So they didn't need to say, oh, by the way, you do know that one contract is time barred, and that's the contract that applies. So you need to adjudicate within those timescales. So I think the key principle here is that relying on an argument that the other party is in breach of the mutual trust and cooperation clause is going to be limited to a fairly discrete scenario. Having said that, since this case, so in the last 6 years, I've probably argued it probably 3 or 4 times where, there've been circumstances where we've thought that the project manager hasn't been completely straightforward. So, it is worth considering. Bear it in mind. Only use it in this scenario where there has been some deception or, failure to correct a false assumption, because it is an effective argument to use if you can use it in those circumstances, because nobody likes to be, called out and, told, you're in breach of the most important clause in this contract. So do use it. But what I would say is, use it cautiously, because what you can find is if you just use it for any argument, it just starts to look as if you've got no real valid argument, and it's kind of sometimes regarded as a sign of desperation. So as I say, use it. It is surprising, the circumstances that come up where you can legitimately use it, but do not overuse it. Don't just chuck it in to any claim in the hope that it may help, because as I say, it just does not help your position. Next slide, please. So the next case is a procurement matter, Henry Brothers and the Department for Education for Northern Ireland. So Northern Ireland case, so persuasive, and this one actually goes back to 2008. And I've put this one in because it shows how often parties misunderstand the pricing mechanisms in NEC, and also because, again, I've used this successfully on at least 2 or 3 occasions where procurement challenges have been made. So basically, the tender because it was EU procurement rules, the tender has to achieve, see the 4th bullet point, the most economically advantageous tender. So this meet criteria. So that's how typically a contractor will be chosen from an EU procurement process. So we're talking about public bodies, utilities, etc. So what the tender required for this particular piece of work, and as you can see from the first bullet point, it was, you know, 550 to 650 million pound contract. So, you know, a decent contract in value. What they judged the economic value of this contract by was the fee percentage. So that was the only thing it considered. And of course, you'll know that fee percentage is basically overhead, profit, few of the little bits and pieces. Henry Brothers were upset because they weren't awarded the contract and therefore took the matter to court and said, you know, this meet criteria was ridiculous because you couldn't assess the most economically advantageous tender by just looking at a fee percentage. The defence was, and it's in this, the bullet point that says held, second bullet point, that the schedule of cost components would be the same whichever business was awarded the work. Now, you know, we should, if you were here last month when we did the schedule of cost components, you'll know that that's absolutely not true. Because if, for example, you look at people, and the people cost in the schedule of cost components, you know, what, for example, labourers are paid from business to business may vary. So that means that the sums included in the schedule of cost components will vary from business to business. So the court said, actually, this does not meet the meet criteria, and therefore it had to be re-procured. A new procurement process had to be started. So again, you know, I said that I've used this where, not kind of entirely in this scenario, but scenarios where the pricing that is given in the tender bears no relation to how the work, once the contract is awarded, is costed. And there have been several instances of that where, for example, you know, the tender requires a certain project to be priced. So that's one exercise. And then separately, it also requires a schedule of pricing to be provided. But the example work in the first scenario, the costing of it hasn't necessarily borne any relation to the schedule of prices. So basically, the contract's awarded on the basis of the example piece of work and how that's costed. But the schedule of prices are different to that. So anything there in procurement where what is actually priced for the tender and how the work will actually be priced, where they're different, you know, there is a real argument under this case for the matter to be retendered. Next slide, please. Okay, so payment. We've got a few cases on this. This is a Scottish case, 2012. And so all of these cases are sort of a similar theme. So in this one, and it's the third bullet point, rather than having a usual monthly assessments that are provided for in NEC, the two parties sort of developed their own kind of non-contractual mechanism where, it's the third bullet point, the QSs for each party got together every month, agreed the work that had been done, agreed how it was, you know, how it would be priced and paid, and payment was made on that basis throughout the project. And then at the end of the project, the employer looks and thinks, oh, I think I've paid too much here. So made a claim to arbitration, which is analogous to court proceedings, to say that it wanted to be overpaid. Now, this is a slightly kind of techie legal point, but the employer was basically saying, I've overpaid, the PM stroke QS and the contractors QS haven't followed the contract properly because they haven't carried out that monthly interim assessment process. The QSs have just got together and agreed something. So therefore, payments have been made in breach of contract. So I'm just entitled, this is the employer's argument, I'm entitled to be paid the money back, and contractor, has to prove its claim. And the court said no. And this is a real theme running through NEC. What the court was looking at was, as the project was going along, the parties, the two QSs, who were involved and knew most about the project, were getting together at the time when everything was fresh in their mind and deciding how payment was to be made and what was to be paid. And there's a real kind of undercurrent in lots of these NEC cases that what happens through the project has some credibility and has more credibility than somebody coming along at the end of the project, namely the employer, and saying, oh, I've paid too much, I want my money back. Now, this was essentially about who had the burden of proof. So what the court found was that the employer had the burden of proof to prove exactly what, if anything, it had overpaid. Now, you might think, oh, well, that doesn't really, help anyone, but it means that the employer has got to show every pound and every pence that it wants to claim back and show why it's entitled to it. And particularly in the context of two QSs looking at it at the time when it was all relevant. So I think this is a really important theme, particularly in circumstances where employers at the end of the project want to claw money back. So if we can move on to the next slide, which is a similar case. So this is ICI and Merritt Merrill. Now this case features twice today. So this one was a similar scenario, interim payments, and the employer, ICI, wanted to recover some of the money made. And again, and I think it's the penultimate bullet point, the second from last, ICI must show good reason, particularly when the PM had certified money at the time. So again, this undercurrent of what happened at the time, which has a lot of credibility, rather than at the end when somebody looks and thinks, how much? I need to claw some money back. Next slide, please. And this is a very similar one. So this is the third of these three cases, slightly different legal arguments. In this one, it's every lawyer's nightmare, to be frank. So this is a 2015 case. So it was a term service contract, option C. So term service contracts, often problematic in terms of payment. Option C with the pay and gain sharing, adds to that. So what happened was the contract rates were agreed and incorporated into the contract, but the contract was never signed. It wasn't executed. The work started with everybody agreed that was fine. Work started, and very quickly, as in my experience is often the case, the parties realised that the contract rates in a contract that hadn't actually been signed, but the contract rates didn't really work in relation to the work that was being carried out. So the parties sat down together and agreed what they called the composite rates. Used those composite rates, saw everybody happy with them. Then the contract was signed. Now, unfortunately, the contractor didn't say, actually, no, we're not signing this contract because it doesn't reflect what we've agreed, because it still contained those contract rates, which nobody was using. So ideally, in an ideal situation, contractor would have said, no, we're not signing that. It doesn't represent the agreement. What we need to do is remove the contract rates, put in the composite rates. That didn't happen. Towards the end of the project, employer realised that they'd wanted to make a saving, but they considered that by using these composite rates, they hadn't made that saving, and in fact they thought they'd overpaid. So again, trying to claw back money at the end of the project. Now this was based on an estoppel argument, but it was on a similar basis to the other, or similar logic to the other cases. Both parties had engaged and used a different mechanism than the one in the contract, and therefore the court was saying it's really difficult now, you know, months later, to then start to say, oh, actually, you know, I don't want to operate on that basis. So I think the key thing here, and I often get contractor and subcontractor clients saying to me, well, you know, I've done it this way throughout the contract. It's not enough to say I've done it this way and it doesn't comply with the contract. We need to show that both parties, and all three of these cases show that two parties, and I'm including the PM in this, agreed a way forward and a way of operating which was not wholly in compliance with the what the contract says. So, you know, just be careful with that. It's no good, you know, if you say, well, we've done it this way, and you know the other party didn't object. There's got to be engagement by both parties in, you know, what's being done. But what we see here continually is that the court supports what the parties have done through the project. Next slide, please. Okay, so I think we've dealt with this in January, February, and now it's March. This is, to me, the most important case. So again, it's sort of similar to the last three that we've seen, in that it's about pricing. So this is pricing CEs. It's a Northern Ireland case, so it kind of comes with a bit of a pinch of salt. You know, will the English courts follow it or won't they? And basically, what the court found in this case was that where a CE quote had not been accepted by the employer stroke PM, and the matter subsequently went to court, that or adjudication or arbitration, at that point, typically the work which is the subject of the CE will have been completed. And the court said what we're used to seeing in this scenario, which is what we would see with JCT and all the other construction contracts, is evidence from the party wanting to be paid, so the contractor or the subcontractor, as to what the work, the CE work, has cost them. And that includes providing invoices, timesheets, etc. Now, that does not entirely fit in with NEC, which requires, if there's a CE, you provide a quote. The vast majority of that quote typically will be based on an assessment of future work. We've dealt with the switch date, I think, in January, so it's different depending on whether the contractor is required to notify a CE or whether the employer is. But what NEC has continually emphasised is that that switch date does not change. And to me, that supports the switch date is before the switch date, contractor submits its quote for actual cost incurred. After the switch date, it's always projected prospective costs. And that supports the fact that that is how CEs are to be assessed and calculated. So to my mind, the court's gone against the whole ethos of the NEC contract. And if you take it one step further, that principle would also apply to delay. So it means that all of the prospective programmes that have been provided would then actually be irrelevant, because what we're looking at is actual delay. So, you know, it's a really strange case. It can be explained by the fact, as I said, the court was in its comfort zone in asking for details of actual cost and receipts and timesheets, etc. And also what you can see from the bullet points is that the parties didn't really operate the CE mechanism properly, notifying CEs, requesting quotes, etc. Having said that, it was the employer who really failed to operate the contract properly in that regard. And, you know, as a result, it seems to have benefited from not operating it. But I think, you know, it's the only case that we have at the moment. So the pragmatic position is that, unfortunately, contractors, subcontractors, when you have CE work, I think not only do you have to submit your quote, and actually I think, you know, it's helpful to make the quote as detailed and explained, as well explained as possible, but you also need to keep the evidence of the actual time, the actual money incurred in carrying out the CE work. So, you know, you need timesheets explaining who was working on that CE on a particular day, how many hours they were working on it, so that then you can apply the cost of those people for your CE, ditto plant and machinery, etc. So, you know, I agree that's pretty onerous, but equally, if you don't have that information, and this is where, you know, it comes in with regard to you negotiating with the paying party. If you haven't got that documentation, then you might find that the paying party just says to you by way, well, we're not negotiating, because, you know, you are not going to get anywhere in adjudication when all you have is your quote. Because you've got nothing to back it up in real cost, you can't comply with this case, and therefore we don't think you would be awarded anything at adjudication. Now, I would like to think an adjudicator would award something, but of course you're not going to maximise your claim, and there is a risk that without any substantiation, an adjudicator might not award something. So I appreciate you will not be preparing for adjudications. You'll probably get your lawyers to do that, but being able to show your employer, the paying party, that you have all of that backup will help in your negotiations to try and settle matters before they get to dispute stage. Next slide, please. Payless notices. This really just confirms what we know already about payless notices. 2022 case. Payless notices are all in the context of the Housing Grants Act. And what happened here was there was, this is the third bullet point, an application for payment number 24 for 5.1 million, followed by the next month an AFP number 25 for 5.2 million. For AFP 24, no payment notice was issued and no pay less notice. So you can see that straight away heading towards a smash and grab adjudication for lack of a notice. So claiming party would be saying, I've applied for 5.1 million on the basis of smash and grab. You haven't disputed it. I'm entitled to be paid for it. For the application 25 for 5.2 million, the paying party, the contractor in this case, issued a payment certificate and also a pay less notice. Now, the pay less notice was issued on the day before the pay less notice was due in regard to application for payment number 24. So what the paying party argued for application 24, no smash and grab, because there was a pay less notice that was submitted within time. The court looked at it and said, yes, there was a notice that was submitted within time, but if you look at the payment, the pay less notice, it is marked AFP 25. So that looks like it's regarding AFP 25, not 24. And if you look at the detail of the pay less notice, it talks about the £5.2 million claim, i.e. application for payment 25, not application for payment 24. So the court said, no, there was no pay less notice for that application for payment 24. It was clearly relating to 25, and you can't do a sort of, mix and match. I'll submit various notices and, just say they apply to whichever one suits me at the time. So paying parties need to be really careful. It's common knowledge that all of applications for payment, all of these notices should need to be clearly marked, so it's clear what they relate to. There's plenty of opportunity, even if an application for payment is submitted, if you don't think it's valid as the paying party, there's plenty of opportunity to say, we don't think this is valid. We are submitting this payment certificate, payment notice or pay less notice without prejudice to our position that it's not valid. That's the safer thing to do than simply ignore it. So in this case, the adjudicator said that the court said that the pay less notice wasn't a valid pay less notice with regard to AFP 24. Next slide, please. Next slide, please. Very quickly, so this is about omitting work, and a bit of a spoiler alert. The work was omitted outside of the scope of the contract. So it's Van Ord and Dragados. Dragados was the contractor, Van Ord was the subcontractor. And the subcontract allowed Dragados to omit Van Ord's work if work was omitted up the chain in Dragados's contract with its employer. So that was all fine. But what Dragados did instead with regard to the subcontract was omit work, even though it hadn't been omitted in the main, in the main contract, the contract up the chain. So the issue arose as to how was this to be costed? Should it be costed as a compensation event or not? And the court said, well, the omission of the work by Dragados was in breach of contract. There was nothing in the contract that allowed them to remove this work. Now, this might have been on the basis that the reason that it was removed was that unknown to Van Ord, two other of Dragados's subcontractors had it was soft dredging works in their scope, and that was the work that had to be omitted from Van Ord's subcontract. So those are the facts behind it, which might have influenced the court, but of course it was nothing to do with this criteria in the contract allowing an omission if things were omitted up the chain. And what the court said was that that's therefore a breach of contract by Dragados. They weren't entitled to omit that work, and therefore the quantifying of the omission didn't need to be confined to the limitations of this, the way a CE is calculated. It could be wider than that because Van Ord were the kind of victim of the breach of contract. Next slide, please. Next slide. Very quickly, this is regarding a fixed price contract, so an option A. It's quite an old case now, Atkins against the Secretary of State for Transport. So this was a management contract, so another one of these problematic long-term contracts for the maintenance of trunk roads. Oh, actually, I've just spotted. It's the third bullet point. It says Atkins was to maintain trunk loads, so it should be trunk roads in East Anglia. Fixed price contract. And problems occurred where Atkins encountered far more potholes than it had factored into its price. Unfortunately, it was a fixed price contract. And as we know, if you've got a fixed price contract, you're taking certain risks. And the court said that it didn't matter that Atkins had encountered more. The fact was it was a fixed price contract, so they were obliged to remedy those potholes within the fixed price, and it wasn't a compensation event under the physical conditions. Now, I think a good way that one of the things that the court looked at, and I think this is a good sort of test, what the court said was how would we quantify this if we decided it was a compensation event? And basically, it's impossible to quantify because the contract didn't say, you know, this is a fixed price for remedying 2,000 potholes. It didn't quantify the number of potholes or the volume of material to be used in remedying them. It just said remedying potholes. So the court said this is impossible to quantify because clearly some potholes were included in the contract. It was a fixed price and therefore all the potholes were included. So just be careful because, you know, as I previously alluded to, these long-term contracts and their pricing mechanisms, in my experience, are often cause for quite costly disputes. Next slide, please. Right, we'll skip over this one. Next slide, please. Right, so 2019 case. This is relating to the target costs. So in this case, it was an option C, so one of these pay and gain sharing contracts, but it also applies to option D. Now, if you read this, initially you might think, well, why is this relevant to NEC? Because it was a joint venture agreement, that's JVA, but it was based very, very heavily upon the NEC option C contract. The clause relating to the pay and gain says that the pay and gain allocation or distribution, you know, so whether, you know, if there's a gain, you know, it might be shared 50-50 between the parties, or if there's a loss, then again it might be shared in certain proportions between the parties. When that is determined is stated in the contract to be at completion on a provisional basis, so not before completion. In this instance, Interserve wanted to stop paying Doosan because they could see that they were already in a pain situation, but they hadn't reached completion, and they went to court, and the court said no, the contract says you've got to keep paying until you get to completion, and it's only then that you have a reconciliation. And if you're in a pain situation, then, you know, the chances are the party who has been paid has been overpaid, and some of it will have to be paid back. Now, I think this is important because I think what we might start to see is employers changing this part of the contract where they're using options C and D to require a reconciliation at earlier stages through the project. So I think it's just to be aware of for contractors and subcontractors, so that you can look out for such an amendment in the Z clauses and be aware of it, and either, you know, use before you actually sign the contract, get it negotiated out, or just so that you're forewarned that will happen if the contract gets into a pain situation. Next slide, please. And the next slide, please. So this case is about defects, 2020 case, bit of an unfortunate one. And I think the moral of the story here, I suppose for employers and contractors in a subcontract is just be really careful with your scope of work or your works information, depending on which NEC contract you're working on. In this case, you can see from the third bullet point, there was a £6 million claim for defects, and the final bullet point shows that the council, Blackpool Council, were only awarded 1.1 million, and it was basically down to problems in not being able to show that the scopes, the works information had strict design life obligations. So, you know, it's a lesson to both parties. You know, contractors alike, you know, if you can't build to certain design lives, you know, you need to get those negotiated out of the scope, stroke works information. Next slide, please. See, where are we? Right. So this 2015 case, SSE and Hockteeth. So this is an sort of an insurance case. So it's an old NEC contract, NEC 2. So the work carried out was partly related to the construction of a tunnel, which unfortunately collapsed. And a claim was made under the contractor's all risk policy, which was in joint names. So ordinarily in a construction contract, you know, that claim would just proceed. Both parties would liaise with the insurers and eventually the claim would be paid. So the contractor's cash flow wouldn't be impacted as such. However, 6 bullet point down, NEC contains a clause at 83.1 that states that each party bears the risk of its own negligence. So what happened here was that the employer started proceedings against the contractor on the basis the contractor had been negligent, which is what had caused the tunnel to collapse. Contractor said, you can't sue us, we've got insurance, it's a joint names policy. And the court said, well, actually, this clause 83.1 says that yes, contractor can be sued because each party bears the risk of its own negligence. And it might be that insurance pays out later, but actually you contractor, you know, have to bear that cost in the meantime. So I think the point here is that, you know, in an ideal world, if you're a contractor or a subcontractor under a subcontract, you would want to amend that clause so that it is only relevant where insurance, you know, insurance money has already been paid, just to prevent cash flow problems. Because of course, at the end of the day, you know, that's why, you know, contractors have insurance. Okay, it benefits the contractor in terms of cash flow and, you know, covering them for claims, but it also benefits the employer in that it, you know, it knows that it's not going to have to pursue the contractor and potentially put it into liquidation because the insurer will pick up the claim. Next slide, please. Right, so pretty much all of the rest of the cases relate to dispute resolution. So there's a couple here that relate to the requirement to adjudicate before a party goes to court or arbitration. So that's clause 93.1 of the NEC contract. So this was about whether it fetters the right to refer a dispute to adjudication at any time, because that's what the Construction Act, the Housing Grants Act requires. And the court said, no, you can adjudicate at any time. You cannot start court proceedings or arbitration proceedings at any time. You can only start them after you've adjudicated. Next slide, please. Now, that doesn't mean that you can't agree between two parties you know, okay, we agree we don't want to adjudicate, we want to go straight to court or arbitration, but without an agreement, you've got to adjudicate first. Similar principle on this one. Final bullet point, what the court did say is one exception to this rule is if you were needing to start court proceedings to protect limitation period. So the limitation period typically is 6 years, 12 years from completion if the contract's signed under a deed. If it's not signed as a deed and it's just a simple contract, then it's 6 years from completion. So in that scenario, you would start proceedings, so you'd file the papers at court, and then you would stay or suspend the court proceedings and move on to adjudication, get your adjudicator's award, and then you could take up the court proceedings or not, if you didn't need to. Next slide, please. And then this case, 2021 case, similar point, but in this one, one of the parties argued that actually we can't possibly adjudicate this matter. It's far too complicated. It's a huge value, and the court said, no, actually, nothing is too big or too complicated to be dealt with in adjudication. Next slide, please. Notice of dissatisfaction. So this is a 2022 case. So again, it relates to adjudication. So what happens is you adjudicate, you get your adjudicator's award or decision, and typically that will require one party to pay the other some money. If either party is unhappy with the adjudicator's award, the adjudicator's decision, what the NEC contract says is within 28 days of that decision, if you're unhappy, you've got to serve on the other party what's called a notice of dissatisfaction. Now, it's not complicated, the notice of dissatisfaction, we'll come back to that. But if you fail to submit that within 28 days, you cannot take the matter to court to argue a different outcome, because as we know, under the Housing Grants Act, an adjudication is only binding until it's been properly determined by court or the parties have reached an alternative agreement. Now, typically, the parties will accept an adjudicator's award, but my advice to clients is always serve the notice of dissatisfaction within the 28 days, because assuming that there are elements that you're unhappy with, if you've had a fantastic result, don't serve it. But if you are at all unhappy with any element, serve the notice with regard to that element or those elements, and it gives you the right, it leaves things open for you to fight another day effectively. And what the court said in this case is that first of all, that the notice of dissatisfaction was too broad. Now, I don't think we need to get too wound up about that. I think the key is that the notice of dissatisfaction has to state the elements of the award that you are unhappy with. So it needs to be carefully prepared, but there's no special wording to be used. It's not like drafting court papers or anything like that. All it is a notice to the other side. But what the court said was you need to consider two different challenges. So the first is your general right to go to court on the merits of the adjudication. But also you need to consider whether you're also disputing on the jurisdiction of the adjudicator, so challenging the award on the basis of the jurisdiction. So what might that be? Well, the merits are things like, the adjudicator awarded 2-week extent for more additional time. You've applied for 10 weeks, so you're not happy. So you're going to go to court and get the court to make a decision and, hopefully give you more than those 2 weeks. So that's the merits. Jurisdiction is some things like where the adjudicators in breach of natural justice. So typically that might be where the adjudicator makes a decision on its view, the adjudicator's view of the contract, which might be different to both of the parties' submissions. And in that case, what the adjudicator should say is, you know, hey, I've found this clause 27 in the contract. I think that's relevant because I think it means A, B, and C. What do you parties think? And give them the opportunity to make a submission. That's what natural justice is about. So if the adjudicator doesn't do that, then they're in breach of the rules of natural justice, and the adjudication award would not be enforceable. Similarly, if, for example, there are all sorts of jurisdictional challenges you can make if there's no dispute. So, for example, there's been a previous adjudication that's already determined that point, and then the adjudicator in the second adjudication determines that point differently. You know, that would be a jurisdictional ground. So there are all sorts of grounds. The key is those grounds, challenges for jurisdictional grounds for the adjudicator's decision also need to be included in a notice of dissatisfaction, or you can't argue them later. So the next slide, please. Right, very quickly, forgotten about this one. Time limits. So you don't need to be too concerned about this, but option W1 of the dispute resolution procedures relate to disputes that don't come within the Housing Grants Act. So that's work projects abroad, so that's construction projects abroad, as opposed to projects in this country. The Housing Grants Act obviously doesn't apply to abroad, and there are some elements of work in this country where the Act doesn't apply. So we've already seen that supplying construction materials to a site isn't within the Housing Grants Act, the Construction Act. So it typically has W1 adjudication procedures. There's also some construction work doesn't come within the Act. So for example, oil and gas construction work, various technical works like that. And so what W1, so then W1 applies. W1 has time limits within which to start an adjudication. Quite strict time limits. My advice is, if you are, for the reasons that we've kind of covered, going to be working under a W1 adjudication clause, you absolutely must get those time limits removed, because they're basically 2 + 4 weeks. So as soon as a dispute arises, so as soon as contractor's notification of a CE has been rejected, PM comes back and says, no, it's not a CE, got a dispute. So you've got to then start the adjudication within that. You've got 2 + 4 weeks to start your adjudication. 2 weeks, I can't remember which way around it is. I think it's 2 weeks to serve your notice, 4 weeks to serve the referral. It might be the other way around. So really hideous, and I think quite unachievable time limits. So they need to be removed. In summary, though, in this case, the party didn't comply with those time limits. What the contract says, if you miss the time limits, then there's deemed to be no dispute and you can't proceed. The court upheld those time limits, so the party couldn't proceed. And of course, as we've seen, there's no option to think, oh, well, we can't adjudicate, we'll go to court, because under NEC, you've got to have an adjudicator's award. You've got to adjudicate first before you can go to court. So just be really careful about that. But why I wanted to refer to it in this context is that this shows that the courts will operate these strict time limits. So by analogy, 8 weeks to notify a compensation event, what the clause says is if you don't notify within the 8 weeks and remain contract, under the subcontract it's less. If you don't notify, then you're not entitled to any time or any money. So this case shows that the courts will uphold these clauses. And if I'm acting for a party where we want to say that the other party hasn't notified within the timescales, I will use this case to support the point that adjudicators' courts have got to uphold these clauses. So just be careful about that case. And next slide, please. I think this is the last one. Yeah, changing the project manager. So this is the second ICI and Merrill case. The project wasn't going well for ICI. Second bullet point, it had gone from 1.9 million to 20.9 in cost. And ICI at the start had an external consultant PM. They sacked that PM and engaged somebody who was an employee of ICI. The court said, no, you can't do that. If you want to do that, the only circumstances you can do that is A, if initially the named PM in the contract was an employee of ICI, or if NEC had been amended to say we're entitled to sack the PM and engage somebody as replacement PM who is employed by us. Now, I think the backstory to this was that ICI were looking to try and save costs on this, and the court didn't like the way of doing that because, of course, typically a PM will have some element of independence in terms of particularly the payment regime, and the court felt that ICI were trying to avoid that by engaging as PM someone who was an employee. And also finally note the Costain v Bechtel case 2005, one of the earliest NEC cases, where the court said that there is a duty on the PM to act impartially when it's making its interim assessments. So I think that's everything. If we can just move on to the next slide. Yes. So happy to answer any questions as always. By my standards, I've done reasonably well just to overrun by a few minutes. My email address is on the, I think the final slide. So happy for you to email me with any questions. Yeah, there it is. But happy to answer any now if people have got time.
There's no questions that have come in on the chat, Sarah. So I'll assume that that means that there is no questions. But like Sarah's just mentioned, guys, you do have her email address. But thank you very much. Another really good webinar, and thank you everyone for attending today's session. Our next webinar is construction case law, and that is scheduled for Tuesday the 25th of April at the same time. So hopefully if you haven't already registered, you will do. We'll see you for that one as well. So yeah, that's it for today. But thank you so much, Sarah.
Thanks a lot. Bye.
Cheers. Bye-bye.